Welcome, scholars. This is Mr. Myers, Lesson 3.8, Property and Privacy Rights. Here are our objectives. We're going to be talking about a few more important Supreme Court cases and a couple important principles that are embedded in the U.S. Constitution, at least implicitly, if not explicitly. And for convenience sake, we've lumped together property rights and privacy rights into one lesson. There is some loose connection between the two concepts, but this is largely just for a convenience factor. Okay, first of all, property rights. The origins of this are inherent in the concept of the state of nature. This is from John Locke in terms of life, liberty, and property. Of course, Thomas Jefferson used the words life, liberty, and the pursuit of happiness, but this is a fundamental part of the Enlightenment philosophy on natural rights. There are, however, limits on property ownership. So the two examples that we would want you to know regarding limits on property ownership would be local ordinances or zoning rules in eminent domain. There are certain rules that govern what can and can't be done with property, and as long as they're applied across the board and they're not discriminatory, these things are completely constitutional. So you might be prohibited from pouring a concrete pad in your front yard in order to store your RV. These could be city ordinances, they could be subdivision rules, and again, as long as they're not arbitrarily applied, these are largely constitutional limits on property ownership. The other important concept is eminent domain. Eminent domain is when the government takes your property for a particular reason. Now, this reason must be connected in some way, shape, or form to the greater good. They can't just take your house because they want to take your house. The best example to use would be that we need to build a new highway and your home is in the way. The government might buy up those few homes that are in the way of that project, and as long as you are compensated justly for that, you're given fair market value for the price of your home, this is something that is completely constitutional. There are some debates on this. If you look on the right, there's questions about what's good public use. Is building a highway? I think most of us would agree that's probably okay. But what about taking private land and giving it to another private owner to build a casino or an NFL stadium? This is where the law gets a little bit murky. And as in all things, due process must be followed. If you feel like you haven't been given fair market value, if your property was purchased under eminent domain rules, you could take the government to court. Okay, so on to privacy rights. So in general, there is no explicit right to privacy that's embedded in the U.S. Constitution, but it's mentioned and alluded to in a bunch of different places, most importantly in the Bill of Rights. We have specific aspects of privacy that's embedded in terms of our beliefs. That would account for the First Amendment. In terms of your home and quartering soldiers, that would be the Third Amendment. And of course, the Fourth Amendment protects against unreasonable searches and seizures of your possessions and your person. In addition, the Ninth Amendment protects all the rights that are not explicitly listed in the Constitution, so you could also make the argument that privacy is embedded there. But the key idea here is that the word isn't explicitly mentioned in the document. We have what Supreme Court refers to as a penumbra of privacy rights, which is this idea that it's almost like shadow rights, that it's alluded to and it's embedded and it's kind of there even though it's not explicitly mentioned. So ultimately there are two schools of thought, and depending on whether you're a teenager or a police officer, or you might have different views on this. But generally speaking, there's a broad interpretation that yes, privacy rights are embedded in the Constitution, and there's a narrow one that says, sorry, the word isn't explicitly there, so it's a very narrow view of this. The broad interpretation is the one that the vast majority of the country and the courts kind of use. Okay, so a couple key cases that you need to be familiar with. First of all, Griswold v. Connecticut is a landmark case. The court ruled the state cannot ban contraceptives because of a right to privacy. And then that idea was furthered in Stanley v. Georgia, which basically said that you have the right to view pornography within the confines of your own home. Please take a moment and read the words of Thurgood Marshall from the Stanley v. Georgia decision. Pretty much everything you need to know about the standard from Stanley v. Georgia that applies on this general idea of privacy in the home is listed there. Now, a case that many of you have probably heard of is Roe v. Wade of 1972. And this basically legalized the right to have an abortion. The court ruled that the right to privacy includes a medical decision to have an abortion. And it established this trimester system. And according to this ruling, in the first trimester, you have an absolute right to abortion. That's the first third of the pregnancy. In the second trimester, those rights are somewhat limited. That right is somewhat limited. Some regulations can be allowed. And in the third trimester, states can actually completely ban the practice of an abortion, except in the case of a threat to a woman's life or her health. Now, most Americans probably don't know, but the standard that was set in Roe v. Wade no longer applies. The standard is actually from a case in 1993 called Planned Parenthood v. Casey. In this particular case, the court ruled that states could regulate and ban abortion after viability rather than this trimester system. Trimester is somewhat arbitrary in terms of dividing the pregnancy up into three sections. Here, the concept of viability means that the fetus could survive outside of the womb, and that may or may not necessarily line up with these trimesters. The court also ruled that all regulations were permitted as long as they did not impose an undue burden. So if you look on the right, this concept of undue burden is the most important thing that you need to understand regarding whether a state can or can't pass a law regarding abortion. So an undue burden has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. So is a 24-hour mandatory waiting period an undue burden? What about a 72-hour? What about mandatory ultrasounds, including transvaginal ultrasounds, where there are some states that actually force a woman to have a vaginal ultrasound, which is inside the vagina as opposed to on the belly, which many people view as a very significant violation of a woman's privacy rights in order to have an abortion. The idea there's being that if you see the heartbeat, you may decide not to have the procedure. Permission requirements from parents, spousal permission requirements, these are all laws that states can place as long as it doesn't provide an undue burden on the woman in order to receive an abortion for an unviable fetus. So other laws in areas of debate regarding abortion would be, for example, states passing laws that say that doctors have to have admitting privileges to a hospital, that an abortion doctor has to have a formal relationship with the hospital, so if something goes wrong, they could admit their patients there. Well, hospitals can deny, if they so choose, like let's say they're a Catholic hospital, they might deny those admitting privileges to an abortion doctor, which means that that abortion doctor wouldn't be able to provide abortions. You could make requirements for clinics to have the same standards as surgical care centers, meaning that their hallways have to be wide enough to admit a hospital bed, which might create a financial burden on those clinics to be able to meet those particular needs. You could put longer waiting periods in play. You could say that and this is the big debate today when people talk about defunding Planned Parenthood, that Planned Parenthood is an organization that provides both abortions but other health care to women, like mammograms and gynecologist appointments and so on and so forth. So some people argue that the government shouldn't reimburse any procedures that take place at a facility that provides abortions, even if they're things like mammograms and so on and so forth. Right now, that the government will reimburse and will pay for those services at abortion or at clinics that also provide abortions, but there are many people who want to see that go away. Well, here are your objectives again. Let us know if you have any questions in class tomorrow regarding privacy rights and property rights, and have a great night.